Okay, so we're going to talk about a few other important points. Again, Cybersecurity Act is not new. It was enforced last year. But today, what we are more focusing on to understand is that other than the Act itself, what what possibly could the Act bring to the business? What kind of impacts will the Act bring to the business? So today, we are fortunate to have 𝗪𝗯𝗲 with us. 𝗪𝗯𝗲 is a very seasoned lawyer. Later, 𝗪𝗯𝗲 will be introducing himself. So these are the topics that we are going to cover today. So we have a brief introduction about the law again, to revisit what has been updated as well. And we're going to talk about subsidiary legislation. There's one new legislation, not so new, but it was released in January 2025, and it's worth mentioning. And we're going to talk about case studies, opportunities, and of course Q&A. We do not have to wait until the end of the sessions. Along the way, if anyone have any questions, please feel free to post. We'll do our best to answer your questions. Background. So a little bit of disclaimer. I'm not a lawyer. So I think that is kind of obvious. I'm not a lawyer, but I'm coming from a technical background. So hopefully today's session, I'll be sharing with you more on to how business, how business will be impacted and by this act, and how business will need to anticipate what is upcoming and what is the obligations for business from a business standpoint and from a cybersecurity technical standpoint. So this is where I'm coming from. So 𝗪𝗯𝗲, over to you.
Thanks, Mr. Fong. I'm also Mr. Fong, but we have no relation. I've done a lot of currently the line of work that I do is a lot to do with data breaches, a lot of scams, a lot of essentially discovering identity of perpetrators. So somehow my work, I actually do a lot of IP work, a lot of trademark counterfeiting and so on and so forth. But the trend right now that I currently face is a lot of breaches and data breaches and scams and all those things. So, example, one of the cases that we were recently doing is client system got compromised, and then payment from the customer went to the third party. So now the question is, can my client claim back from the customer who had paid it wrongly? So these are some new questions of law that we need to deal with in court. So happy to share all this information later. Over to you.
Thank you, 𝗪𝗯𝗲. Yeah, thank you, 𝗪𝗯𝗲. I think 𝗪𝗯𝗲 also published several books. 3 books. And the second edition of the Cyber Electronic Evidence Information Law is pending to be released or has been released. Has it been released?
It's been released. Actually, there are two editions. The first edition was done some years back, and the new edition is about 1,000 pages. Because it involves all sort of cyber law, IT, and electronic evidence cases in Malaysia. So I've compiled all these cases and I wrote it as a textbook. It's actually more for lawyers to use in court. But I understand that the academician universities have picked it up for use now. Even non-lawyers are using it. So happy to have it spread out all along.
You'll be surprised. I'm also reading it. The first edition, I finished it already. So what I find it very interesting is the case studies. How these case studies happen in Malaysia and how the court deal with these kind of legal cases. So if anyone haven't been diving deep into cybercrime and how these cases are being tabled in court, I would strongly recommend you to go and check out this book by 𝗪𝗯𝗲, Cyber Electronic Evidence and Information Technology Law. Perhaps someone can post a link into the chat box. So if anyone interested, right, please go ahead and get a book. So I personally enjoy reading the books. It's just like reading stories, and it's interesting to see how many cases happen in Malaysia. All right, so background about LGMS, we are a cybersecurity service firm. We are currently considered the largest cybersecurity professional assessment firm in the country. We specialize in 3 areas of businesses. First is prevention, to help clients to conduct security assessment, health checks, penetration testing, red teaming, and whatnot. The second part of business, we offer security consultancy to help clients to build up security defense, to comply to international standards. And finally, the last piece of business, which is very interesting, the incident response business, where we help our client in relation to cyber crimes and also reacting to cyber attacks. So this is the part of business that is currently we see is growing, and it's not a good news for many SMEs out there, because hackers today, they really do not distinguish the targets anymore. All right, anyone with an online presence, with an email address, with a phone numbers can potentially be a victim. So that means those who have less prepared are usually having the largest or greater impact when the cyber attack hit them. So that is a very strong message I keep repeating to everyone, to anyone that I see. We are really living in a time with cyber warfare that's happening almost at a daily basis. So it is not a matter of when are the hackers going to attack. It's a matter of whether we know it when hackers are already inside our organizations. Whether we know how to deal with it. This is the key questions to ask businesses as part of the business survival questions. Do we know what to do? When we discover hackers are already inside our organization, because hackers are using automated attacks to automate their attacks, and now some more with AI, with a lot of automated scriptings, and most of the attacks we see online today are not done by human, are done by software machines, all coming from various parts of the world, and we just have to deal with it. It's part of life, really, right? So back to the Cybersecurity Act. I think this topic today, I would say Ching Leong is the main star. I'm just more like a co-host to bring up the background and then let Ching Leong do the heavy lifting. So just a quick introduction. The Act came in force on the 26th of August, not too long ago, and not too, I would say is still considered new because many organizations when I spoke to today, many of them are still unaware about the impact of the Act, unaware that the requirements that imposed in the Act. So I think this is the time that we need to continuously telling the public what are the requirements we need to comply if we fall under the categories of critical national infrastructure. Even though we do not fall under the critical national infrastructure, but I still strongly encourage everyone here who runs a business, right, to take this seriously, because hackers do take their business seriously. And if the hackers take their business seriously and we don't, and then that's where we will fall prey. Now, the primary act is to enhance to the establishment of a National Cybersecurity Committee. And the Act also has a very clear definitions of the roles and powers for the Chief Executive CE of National Cybersecurity Agency, NACSA. It also defines the responsibility for head of National Critical Information Infrastructure, NCIS sectors. It defines it very clearly on their responsibilities. And it provides managing cybersecurity threats and incidents affecting NCII, provision of managing cybersecurity threats. And also inside the Act, we also have 4 supplementary legislation, which is something that we're going to talk about, which also talk about the detailed requirements for organizations that need to comply, right? And also another one is the Act also covers the licensing of cybersecurity service providers. Again, these are the the summary of the cybersecurity. I'm going to skip through because I do not want to put everyone to sleep at these early hours. The Act consists of 8 sections. All of these sections has their own definitions, which we're not going to go through. Right, so this is the important part. So there are 11 sectors have been covered by this Act, 11 sectors. Now, some of these sectors seems quite understandable, like quite, I would say, quite a norm, because, for example, we would anticipate that the government, the banking and finance would, of course, be covered under the Act, right? And we also expected that the government sector will be also covered under the Act. But something that is interesting to see that is being covered, which was previously have not been regulated, is agriculture and plantation. Right? Agriculture and plantation, it is kind of interesting to see that we put this under national critical infrastructure. And also another one, healthcare services. Now, healthcare services has long been also a target for cyber criminals, right? Cyber criminals are targeting healthcare data, patients' data, and previously healthcare sector wasn't regulated as much as what the finance industry in terms of cybersecurity. So it's something that I'm quite glad to see that healthcare is now being regulated. But then again, if you look at all these different 11 sectors, right? Not all sectors have the equal amount of capability when it comes to cybersecurity management and even prevention, right? All of them have different exposure, different experience. Of course, I mean, if you're coming from finance and banking sectors, right, most likely, your cybersecurity strategies or defenses are quite matured already because you have been regulated over the years. But coming from other sectors like agriculture and plantations, science, technology and innovations, trade industries, even healthcare, right? You may not have the kind of maturity of what other sectors may have. So then the questions will pose back to the authorities is that do these sectors get any delay in terms of enforcement of law? Do they get any exemptions? And this is questions that I think people operating under these sectors will be interested to know, to ask the government. And I don't think this is something that we can answer, but the point is, cyber threats now affecting across industries. It's no longer a proprietary thing deal with finance sector anymore. It's a problem. It's a business problem that impacting different industries, right? So I'm glad that the government see this and covering 11 sectors. So these are the 11 sectors, and also it's sector lead. For example, the sector lead for the banking and finance will be, of course, Bank Negara, Ministry of Finance, and the capital market will be Security Commissions. Transportation, the sector lead will be Ministry of Transport, and the rest. So different sectors will have this sector lead. The sector lead will be responsible for driving the implementation, driving the regulations for these respective sectors. Right. So Qing-Leong, if you have anything to add on, please feel free to jump in. So there's no particular sequence that we want to go on. All right. So there are 4 subsidiary regulations under the Cybersecurity Act, which I think worth mentioning. So I'm just going to cover from a technical standpoint. So before that, let me just have a pause first. If anyone have any questions, please feel free to post it to us. But Qing-Leong, do you have anything to add on so far at this stage?
Nothing so far. Let's move along, then I'll add.
Yeah. Okay. So let's look at the 4 subsidiary regulations. The first one talks about period of cybersecurity assessment and audit. Now, this is kind of interesting because it actually mandates the need for conducting annual cybersecurity risk assessment and also biannual audits. Now, the thing is, from a technical standpoint, right, I'll have a question when I look at this legislation, because how do you define cybersecurity risk assessment? Is it something that involves in vulnerability assessment? Is a penetration testing considered a risk assessment? Is a typical IT audit considered a risk assessment? There isn't any clear definitions coming from the legislation. So this is very much subject to, I think, the interpretation of the different NCII entities, right? So I think from my perspective, my own personal view is that we should have something more granular, right? Something more fine-tuned, and have a much closer definition of what does the government mean by cybersecurity risk assessment. And also the biannual audits. What do we cover inside a biannual audits? Like, how do we define the content of a biannual audit? This is something that is still not defined, not given clear, granular definitions. That's why it's still subject back to the NCII sector leads to define these terminologies. But from a business standpoint, right, how does one organization prepare themselves, establish a better prevention? I would say annually, at least have to carry out vulnerability assessment, penetration testing to test the resilience of your IT defense, cybersecurity defense, and also carry out cyber drills. To carry out drills, and the drills will actually give you the expose to you what are your weaknesses and what are your strengths, and when it comes to cyber attacks. And also for biannual audits, I think today audit has so many different types of audit, especially when you are coming from a public listed sectors. You have ESG, you have many other audits. So the management or the board are really indeed responsible for defining a clear definition, establish a clear definitions for the audit, and for the organizations to establish a stronger framework in order to maintain a cybersecurity sustainability in long term. Another regulations that's mentioned that is also quite interesting. Notification of cybersecurity incident. Now, these for those regulated sectors, like for example banking and finance, right? This has been long established, way before the act. The bank guarantors will have a very clear guidelines to notify for notifications. Like for banks, whenever you get hit by cyber attacks or you suspect that cyber attacks happen, you have the obligation to report within X number of hours. But now it has become a part of the Act. As the Act mentioned, right, NCII entities need to report within 6 hours. Again, the detailed reports how do you define a detailed report? What should be inside the detailed report? Should they contain a total root cause analysis or initial impact assessment? Or what are the things should be in the detailed report? There's no definition. So it's all subject back to the NCII sector leads to define what are the required items to report within the first 6 hours. And of course, additional information within 14 days. Now, what other additional information also has not been defined clearly? So this is also back to the sector lead. But then again, from a business standpoint, it is good to see that the act does mention about the requirements for notification, because if without this one, if you just imagine this, for example, healthcare, when a hospital is under attack, the patient data got stolen, without the act, right, the hospital may not report the incidents to the authorities, to the public even, right? So this act really made a change to the landscape of cybersecurity. And this is something that we hope to see more often, because whenever there's any breach, public deserves the rights to know, and of course, the authorities must be informed. And this also greatly help to reduce the chances of targeted attack to certain industries. There are hackers who regularly organize targeted attacks against industry. So if these isolated incidents happen within the industries, get reported to the authorities, at least we can establish some kind of overview and to know what to prepare, to notify those operators within the same industry to be more prepared. So I think reporting is a very crucial part in maintaining cybersecurity sustainability. Right? So we are glad to see that these requirements is there. Of course, there's another regulation talk about compounding offenses, various offenses, what are the penalties, and then finally the requirements for licensing of cybersecurity service providers, the number 4. So licensing is an important, I would say, is an important mechanism. But there's a but, by the way. But what we have experienced so far, I mean, this is still at a very initial stage. So what we're hoping that is that the government will have a much stringent and stronger requirements when it comes to providing license to cybersecurity service providers. But I do believe that this mechanism can get more matured over time. So when we reach the point of maturity, the licensing scheme will be much stricter, and then we will have an assurance that those who get licensed are really truly cybersecurity service provider and trustworthy. And hopefully this mechanism we can get matured over time. Right, so Chin Leong, you have anything to add on this?
Yep. Sorry, I'm busy answering questions in the chat box now. What I want to say is that although some of these NCII entities and sector leads you may not be part of it, but a lot of us do service this industry. So when these obligations are imposed on the lead or the entity, this obligation will also trickle down to all the subcons and all the subcontractors. So knowing all these obligations is also important to everybody, especially when there's code of practice. As the service provider, you also must know the code of practice and so on and so forth.
Chin Leong, I have a question here, because this is also being frequently asked by many people. Let's say, for example, I fall under NCII. I am, let's say I'm a hospital, right? I fall under NCII area, and I have gotten the instructions from the sector lead to tell me that I need to carry out some cybersecurity defense prevention and all that. So somehow I got hacked, right? I got hacked, and then after the investigation, I found out that actually it's my supplier's negligence that caused me to be hacked. For example, they deploy something, they didn't change the password, leave it as default. So now when it comes to the act, right? Do we have anything we can use against the supplier, or we can claim anything that against the supplier?
So it's going to be a contractual obligation or contractual term that you can rely on. If there's no contractual term, then it will have to rely on the obligation of the tort of negligence. Usually in an agreement, service agreement, you have indemnity clauses. So what is important is you need to look at indemnity clauses. What is that obligation for the contractor to say that I will compensate or will pay you back whatever damages that you suffered. Then you as the service provider, of course, you as the main principal will also want to see whether there's a limitation clause or not, because a lot of times the subcontractor will put in a limitation clause. The limitation clause normally will say that whatever you pay me will be the limit of the amount that I will compensate you. So be very, very careful when you look at your service contracts. So don't just sign it without reading it. Preferably have a lawyer or someone else to zoom into things, mainly indemnity clause and the limitation clause, these two things.
Okay, good. I think we'll dive in a little bit deeper about this question. Let's say the contractor caused us to be hacked, and we also lost the ability to be able to establish any kind of evidence to do reporting, right? So meaning that as a hospital, I'm not able to carry out any investigation because I lost all the laws, I lost everything, and I'm not able to prepare a report in compliance with the Act requirement to report it within, let's say, 6 hours to have a report. I can't do anything, right? So when it comes to the law, obviously I'm breaking the law already. I'm not able to report within 6 hours. I keep dragging. Okay, so who will be accountable for this? Will the hospital be accountable, or can we still find a way to transfer this risk?
No, the obligation always lies on the hospital. The entity is always responsible in preparing anything in the obligation. So what the hospital has to do is to, of course, to ensure in contractually terms is that they also must contractually, they're obliged to help, and you must ask for compensation or whatsoever from the other side to compel you. But let's say this guy, if you got someone from foreign, for example, another country, if the guy doesn't reply you, then you are in terrible position, because you will not, maybe it'll be very difficult for you to take legal action against him in Malaysia. And if you filed it, let's say in a country in India, it's going to take you some time because the judiciary there has a lot of ongoing cases. So I think you need to pick your subcontractors very, very carefully, especially when you're going to deal with a lot of data and some confidential information.
Yeah. I think the reason why I bring up about contractors is also because nowadays hackers are really banging hard on the supply chain attack. Supply chain attack basically means that instead of focusing on the target themselves, but we're focusing on the supply chain of the target. Who are the suppliers of the target? Who are the providers for the targets? Who are the targets are working with? Right. Another example is that, for example, if I want to hack into the hospitals, right, I probably will not hack the hospital's infrastructure. I will be targeting the hospital suppliers. I may be even targeting the equipment manufacturers who supply the equipment to the hospitals. Right. I will once I hack into, if I'm a bad guy, I'm a hacker, I hack into the manufacturers, I install a backdoor into the equipments. When the equipments get deployed into the hospitals, that's how I get into the hospitals. So this cyber supply chain attack is a norm today, and history have taught us many lessons. I mean, over the years, we have seen many cases happen because of supply chain attacks. Some of the notable cases like the 𝗖𝗆𝗯𝗏 incidents, 𝗖𝗆𝗯𝗏 target hacking cases. There's so many hacking attacks are all focusing on supply chain attacks. So today it's no longer important to ask, are we ready, or in terms of cybersecurity defense, we have to ask, are our suppliers good enough? Are our suppliers ready to defend or to prevent, to have any mechanism to protect themselves when they're servicing us, right? So that's why. Sorry.
Yeah. Sorry, I want to add. In fact, I did a lot of cases where actually the attacks were on the supply chain. So we were acting for some of these suppliers and realized that even a lot of the attacks came through the suppliers' platforms, because some of them suppliers had used another third-party software to connect to the customers' platforms. So through that part, they attacked it. Even from emails, service providers also they attack. A lot of times, sometimes it's also due to negligence of the subcontractors, junior staff, for example, the interns forgot to turn off the software and so forgot to change the password and so on and so forth. So as you rightly pointed out, a lot is a real life situation where the attack actually goes to the supply chain.
Yeah, the supply chain. So I think one of the things that I didn't see this mentioned in the Cybersecurity Act. Maybe there will be something in the future to complement this, to talk about supply chain accountability. But But what the Act is currently focusing right now, what I can understand from a layman perspective, is focusing on the accountability and responsibility for those CNII sector operators, right? But I'm hoping that there's one day we can see some definition of the supply chain accountabilities. It means people who supply services, supply products to the CNII, they have to comply to certain things, right? So this is something that I'm hoping to see from a law. Do you think that this is even possible, Jing Nao?
Well, I think it's possible if you look at the PDPA, the Personal Data Protection Act, they do now impose obligations on data processors, essentially people who provide service. So now the data processors also have security obligations to comply with. In the past, they were not. In the past, they were all thrown to the data controller or data user. So the trend is also now moving to the third parties or the supply chains, so that they are also legally obliged to comply and also legally responsible for any fines or imprisonment imposed.
Yeah. I also throw in another questions. Do you see any other regional laws, right, that deals with supply chain, cybersecurity supply chains?
No, I don't think offhand. I do not recall. Singapore would be the best bet to look into it. Currently, as far as I'm aware, no, I don't see any. It is not a very, how to put it, a very developed area. Which because one issue is that, let's say you put the obligation on the supply chain as well, then the data controller or the person, the principal would have a lot of obligation of audit. For example, they have to go for auditing, an audit on the service providers as well. So it may also backfire on them as well.
True. Yeah. I think it's not an easy feat, but then again, without the law in place, right, I strongly encourage every organizations today also take this very seriously, because it's no longer the questions of how secure you are. Your suppliers, we need to look at their security posture. There are services that in the market that you can get intelligence about your service providers. You can get cybersecurity threat intelligence about how vulnerable or have your suppliers been impacted before. Have they suffered a data leak before? There's a lot of threat intelligence available in the market that you can inquire, and then the providers, we can help you to understand more about your suppliers. Right. So moving forward, let's look at the dive into the act itself. In the act, there's a section mentioned about the power of authorities. Now, from a layman point of view, I'm seeing that the act is actually granting 𝗪𝗔, the chief executive of 𝗪𝗔, a sheer amount of power to carry out many things, right? So it's given the chief executive a lot of power. So Qing Nao, what do you think about this act? Is it normal, or is it something out of ordinary?
Is something I would say quite interesting, giving powers to this chief executive. I remember reading it and thinking that this is sometimes too much power to the chief executive. So so far we've not seen any abuse yet or any complaints against the chief executive. We will yet to see whether for example, if he does something above his powers or something that is unreasonable, whether we can challenge his powers in the court or not. So we're waiting for that kind of cases in court, so that we can test the roles and obligations of this chief executive.
Yeah, so far there isn't any precedents even. Has there been any NCII or any any sectors that precedents so far?
So far, no, I have not seen it. But challenging the powers or authorities in Malaysia is quite common in Malaysia. You have to go by way of judicial review, and then you have to go to High Court. You have to do it within the span of I think 3 months. They must file the application. So is not so easy to challenge, but it has been done before.
I see. So it will be interesting to see because the act itself has really granted a huge amount of power for chief executive. There are some examples that we have laid down here. So for example, if you look at some of these things like number 9, investigation power. Authorized officers have broad powers to carry out investigation related to cybersecurity incidents, including powers similar to those of police officer under the Criminal Procedure Code. So my question is, who are these authorized officers? Do they have experience or qualifications when it comes to carry out the investigation and even going to the point of collecting evidence?
I think you have to look to the information gathering there. Number 4 is actually very, very important and very sometimes alarming. Because under the information gathering, the chief executive has the power to direct it for information. He may require any person. So any person means, any company or any one of us direct, to provide information in a specific manner, and all he needs to do is he has reasonable grounds to believe you have the information. And if you do not provide the information, you're liable to a fine of 200,000 ringgit or imprisonment of 3 years. So let's say, one day you have a certain, information that you want to keep, and you find that, disclosing it is is going to be discriminatory or very, very problematic to you. Or somehow, let's say the chief executive says, I want all the database of all your customers on one time. Or they come to the telco and say, I am the chief executive. I want all your subscribers' information to put it into another database for us to check. So you as the NCI entity, or even let's say any other person, you will have no choice but to comply. Otherwise, you will go to jail first. You'll be charged in court first, and subject to investigation. And in the meantime, you want to challenge this thing in court. That will take you a few months, and then in the meantime, you may be lavished, to be in the lockup for a while, and while pending your charge against you. So this part is actually quite concerning when it comes to information gathering.
Yeah. And also there are a few points there I wanted to ask as well. Let's say when you say someone is accountable for this, who will be put in jail and get a fine, right? Who is this person?
Generally the directors. The directors will be the first line of these people. So then it comes to senior management. Generally, no, but you will have people like your compliance officers, partners, manager, secretary. Sometimes these people will be involved also, but generally the directors will be the first line of people being charged in court.
It means they will receive the fine. They'll be looking at the jail terms. Wow.
Yes.
Yes. So this is kind of scary. From others, let's go back to number 9 or so. But you see, I'm very concerning when they say they carry out investigation and they didn't define. I don't know whether there's a place to do a definition of their qualifications or not, because you see, when you carry out investigation and carry out evidence collection on digital evidence, right, the risk of tampering the evidence is so high. Compared with other kind of evidence collection in cybersecurity, evidence collection. If we miss out certain steps, or we mistook certain steps, right, we could have contaminated the evidence. We have made the evidence useless. So I'm just wondering how are they going to establish the strict guidelines, or do they even have a strict guidelines to carry out these things, or not?
So based on my experience in dealing with these investigations, first thing they do is they will take all your devices. They will come in and take all your computers, taking your phones, taking whatever laptop, or taking whatever hard drive, or even sometimes they take your mouse. They take up take up even the modem in your office. So that is the wide powers of investigation. They will take it out for forensic evidence and so on and so forth. So if there is a break in change of evidence, that is very good for you, because once there's a break, there will be a question of integrity of evidence. So many years back, I did one case where there was actually a break in the chain of evidence, but it's not on the police side, but it was on the employer side. My client was alleged to have hacked into the server, and they have taken his computer, and then there was investigation done on his computer. But the computer was taken and kept by the employer in a certain lock cabinet. But when the log file of the computer came out, we realized that the computer was open, started up during the period of retention. So there was really a break of chain evidence, and then we managed to get the clients off because the evidence that was provided had lost integrity. So when it comes to the police investigation, when it comes to a high profile one, generally people like the cybersecurity will come. Cybersecurity or their technical people will come and do the evidence preservation. So they will come, they don't just come and copy and paste your hard drive, for example. They will, what you can do, they will mirror your hard drive. So they will do actually proper evidence retention when it comes to high profile cases. So alternatively, they will come and just take the whole thing. I've also cases where there was an online web service provider. They came in and took the whole server rack, just pull out the plugs and then they left. So this was how they did it in the past. I remember having had this kind of case.
Yeah. So this is also something the business may need to take note. That means the authorities can come in and seize everything, including your entire server rack. And if you have something critical running and you do not have a backup plan in place, or you do not have any kind of resilience built into your IT infrastructure, so your data or your precious whatever assets data will be impacted during this kind of a seizure. Another question I want to ask you, Ching Leong, is also this without warrant. Is it a norm to seize without warrant?
Yes, seize without warrant is actually quite common these days. So sometimes they have reason to believe that there will be, for example, there will be tampering, there will be dissipation, or there will be destruction of evidence. So that what they do is they just come and say, okay, I have a reasonable suspicion that this is going to happen. I will come without warrant. So for example, you see that that guy is going to destroy at any time. You have to go in for that. So if they want to come in without warrant, then perhaps they should justify it.
Okay. So this is also something the business need to take note, that the government officials may come into your office and seize your computer assets without a warrant. So this is something that businesses need to start thinking of. What do we do? What do we do in case this kind of thing happens? Let's say we believe that one of the employees are actually hacking JPN, Jabatan Perdana Menteri, within our office, and we have no idea. And then the authorities found out and came, and they wanted to seize everything in the office, including the laptops, even the servers. So what do we do? Right? So these kind of scenarios is something that business need to start thinking and start anticipating. How do we deal with these kind of situations? So this is something very important. Another question I want to ask you, Ching Leong, also. This one. Okay. 7. Authorization of public officers. Now, minister can authorize any public officers. Okay, this is the part that I'm a bit concerned. Any public officers to exercise power enforcement under the Act. So, is it something that we should be worried about, or is it something that is quite a normal practice?
It's also quite a norm. Public officer generally is people with the expertise and the powers to do so. So they can't just ask, let's say, for example, let's say a sergeant to come and do the investigation. So they normally will come with someone of a certain rank to come in to do the investigation, not just unqualified person, because if they get someone unqualified to do it, then their reasons and their answers in court will be challenged and will be thrown out. So they can't just simply appoint someone. They also will have someone who can go to court and then justify and to support their own evidence in court. So our courts are quite in a way it's quite independent. The trust in the judiciary is pretty good. So we have no issue with them.
Okay, this also bring up to another potentially a hypothetical question, Ching Leong. Will you see any possibility that someone may leverage on this to harass companies? Example, I'll just give you a more concrete example. So, for example, let's say company A and company B, right? If company A wants to do something, wants to harm company B by using company B's asset to attack the government, for example, and then that leads to the investigation of company B. You see that this kind of a scenario, right? These kind of things will be used.
Yes, you can using company B as a scapegoat or as the front to attack another party is actually quite common. We have seen it in hacking cases where the assets of the, let's say in the supply chain organization, they use the supply chain's assets to attack or access the principal's the assets also. So likewise, if that is done, so in let's say in the case that I'm doing right now, is that they use the same assets. The investigation were all against the subcontractor. So the subcontractor now, the problem is they have to prove it's not them lah. They also need to hire. One is they lost the contract. Two is they need to find experts to do it, and three is they have to go to court lah and be subject to heavy legal costs and all sorts of stress to do it. So if let's say a report also was filed, as let's say it's also involved in NCII, then the report must be lodged with the body, so the authorities, and then you'll be subject to further investigation, your computers being seized, your phones being seized, and so on and so forth. So you will have a very, very terrible time.
Yeah. So this is also a reminder for business. Another reminder case for business is that sometimes when somebody hacked into your organizations, right, their intention may not be causing any direct impact to you themselves. Let's say if I'm a hacker, I hack into organizations, I may not just want to benefit from this hacking into organization. However, if I'm more sinister, I have a bigger goals, I may hack into your organizations and use your organization as a launchpad to hack the authorities or hack the NCII, so that it triggers the kind of investigation, the kind of authorities to come to your organization to give you the harassment and to give you the tough time. So this is something that business also need to take note of. I mean, that's why the reason why prevention and protection is so critical today. It's not just because you want to protect yourself. You want to avoid being used by the criminals and suffer the damage from there. Right. So I think we has discussed a few very interesting scenarios already. Let's move on to the next topic. Do we have any questions so far? I mean, from the audience. Let's see.
Yes, Mr. Fong, there are some in the chat actually.
I think one of very interesting questions coming from Eugene Garner. Manufacturing under trade sectors. Is manufacturing under trade sector? I think this is a question. Who do we consult on this? Jingnan, what's your take on this?
Well, we have to go back to look at the schedule of the Cybersecurity Act. So if you look at manufacture, it falls under trade industrial economy. May or may not. May or may not. I think it really depends whether if you have NCII, in other words, do you have the NCII? You are talking about NCII. If you're manufacturing bombs, you're manufacturing very, very important assets for the country, yes, then you fall within that. But otherwise, we're just doing gloves and something not so important to the nation's health and all sort of things, then you not fall within that.
Yeah. I think that the ultimate guideline is still consult with the sector lead. Consult with sector leads to get a much clearer guideline, and it's best to consult and to assume for the manufacturers. We do come across some manufacturers who manufacture medical devices, pharmaceutical manufacturers, and they think themselves they are part of critical national infrastructure. I say it's go ahead. I mean, it's good to be more paranoid than more relaxed. So I think it's good. But the ultimate thing is also, I agree with you. I still see one of the things that you're doing, and the best is also consult with the regulators. So these are the sector leads. They can try to check it out.
So I saw a lot of questions whether this falls within the NCII entity or not. So ultimately, you have to look at what is NCII. NCII essentially is the computer system or computer which had detrimental impact on certain things. These are very important keywords: the security, defense, foreign relation, economy, public health, public safety, or public order. So these are all the few things that you must be affected in order to fall within NCII. So for example, legal services, we are not falling under NCII at all. But telco, straight, yes, definitely it will fall. And then the question about logistic also no, it do not fall. In general, it does not fall under NCII. But if that logistic has a structure, has a system which affects the entire defense or security of the country, yes, then it will fall. So maybe post Malaysia will fall under it. So hard to say. Go back to the sector lead to determine.
Yeah, but I think logically, logistic may fall under NCII because if let's say if there's a cripple action on the logistic industries, right, I think it will impact everyone. Documents get delayed, parcels get delayed, the supplies of materials got delayed and everything. So it may have a chain effect. So potentially logistic is clearer. I mean, clearer that which logistic companies operators are fall under NCII, but somehow others like science, technology, innovation. This is the part that I'm maybe puzzled as well. Who are these operators fall under here? Science, technology, and innovation. Cloud service providers. I don't know. Maybe data centers. Do they fall under here, or they fall under somewhere else? So if clouds, then information, digital communication, and who are these people? Like, in telco, of course, telco are under this, but who else are fall under this sector is also another question. So I think the best way to consult whether you are part of the NCII or you fall under any the regulatory requirements of any of these sectors, the best person to ask would be 𝗪𝗪𝗯, perhaps, or who else? Do you have any idea?
Best is to talk to the sector lead. For example, post Malaysia, logistically, let's say you talk about mails, delivery of courier and all those things, it actually falls under communication. So instead of falling under transportation, so you have to break apart. Let's say again, go back to logistic. Logistic could be transportation, also could be delivery of information and such as postage and so on and so forth. So again, go back to the sector lead to determine. If sector lead cannot determine, then go back to NASCA.
Yeah, go back to NASCA. So I think this is a part that there's still a lot of cloudy confusions but nevertheless, right, as a business, like I said before, anyone can be a target today. So disregard whether the act is in place or not. I mean, protection, prevention is still part of your obligations. As part of the company responsibility, we still need to take care of our own cybersecurity defense, right? So having said that, I also have something interesting here to share. Let me share another screen here. Just give me a second. So this is... Are you able to see my screen?
Yes.
Yeah. So this is also published in January 2025, right? This document talks about exemptions order 2025. Okay, basically in this document it talks about there are 9 companies being listed here exempted from the Cybersecurity Act, right? These are the 9 companies. So Qing asking from a legal standpoint, right? Why do you think that there will be they are exemption in place even?
The law provides for exemption. Perhaps they have demonstrated to the government that they are very competent people that does not need to do all sort of obligations. Or perhaps they have satisfied all the requirements or there are some form of let's say benefits they provided to Malaysia. For example, Google will say that you exempt me from this Cybersecurity Act. I will build data centers in Malaysia and I will invest so on and so forth money into Malaysia. So there may be some form of benefits in return for the exemption. So that could be possibly those are the why they were exempted.
Okay, I'll throw you another questions for the exemption, right? Let's say something happened. Let's say I just pick one, just randomly pick one. This Amazon Data Service Malaysia. Someone's believe that there are terrorist activities. Terrorists is using their data centers, to carry out, whatever attacks to the government. And does it mean that since they're now exempted, the government have no authorities to go in and carry out some of the works that we mentioned, like investigation and all that?
Yes, that's correct. But of course, they do not need to look at the cybersecurity angle. They can still look at the angle of terrorism. They can still act on the angle of criminal. This exemption is only in respect of the compliance of the Cybersecurity Act. the other provisions in law where it involves terrorism, then we have all the criminal procedure code and then penal code, and also on the other provisions of law that allows the authorities to go to investigate. So it's merely exemption of certain obligation under the CSA.
Right. Like say for another example is that let's say the government is hosting one of these providers is hosting their data in one of these providers, assuming there's a breach of the data, right? Breach of data who are hosted by one of these providers. Now, with the exemption in place, right? Does it mean that these providers, they do not need to comply with the 6 hours and 14 days requirements to report to the authority?
Yes, that's correct. So basically, the CSA are the standard that is imposed on the industry, but that does not stop the government from imposing their own provisions, their own requirements in the contract between them. So let's say, for example, the government decides to, yes, I will use Amazon, but in my contractual terms, I would say that the Amazon must comply with the obligations in the CSA. So whatever the requirements in the CSA that's imposed, the same will be imposed on Amazon, but contractually. So that can be done.
So that fall under the contract obligation.
Yes, there could be more as well. There could be more obligations for them because the CSA is supposed to be only the basic base. So there will be more requirements. You can impose more requirements contractually again to all these other people.
So it means that the key here is contractually they need to manage it. Otherwise, they do not need to comply to because they're now exempted already, right?
Yes.
They do not need to comply to the extra requirements in the Act.
Yes.
I have another question. What does it take to be exempted? I think back to the very first question. I think some organizations also wanted to be exempted because they're not ready, or they do not have any intention to be covered under the Act. So what do you think? Aside from returning some benefits to the government, is there any other stronger justification for organizations to request to be exempted?
Oh, good questions. Other than the benefits, well, there could be also, let's say, a threat also. Let's say, for example, Amazon and Google are one of the best service providers in the world. So let's say the Amazon or Google comes and say that, okay, if you don't exempt us, we will decline all requests, all services from Malaysia. So leaving us all crippled because we do not have the best access to the best services anymore. So in Malaysia, we may not have a better alternative or as them, or that if that happens, then we need to train our own people. So there could be also, other than benefits, there also could be a threat. If you do not give us the option, I will not provide service to Malaysians.
It's very true. Which also brings up another question I would like to check with you that may not be 100% related to Cybersecurity Act, which is something about the licensing scheme imposed by the Ministry on social media platform service providers, right? So what is your view about this licensing scheme? Do you think that with the licensing scheme, the platform providers will be more compliant, or it could be something else?
Well, I think the licensing scheme is on platform providers actually very, very important because let's say we're talking about Facebook or Instagram or on WhatsApp or even Telegram themselves. One problem that I deal with daily is the anonymity on the internet and also a lot of scams. So what they can do is they essentially hide behind these platforms. So for me to get the information as a civil service, as a company or individual, is that I need to go and file a court action in the US or sometimes in Malaysia. For Facebook or basically Meta platform, you can still file in Malaysia. But let's say in WhatsApp, would they fight? Would they accept service in Malaysia? Would they agree to provide information and so on and so forth? So then it comes to government. So if you look at the transparency report of all these platform providers, you will see that there are a lot of times when these platform providers reject requests by government to provide information. So by providing the requirement for licensing, in the old days, everybody's talking about freedom of speech, you're clamping down and so, but we have now evolved into the place where the platforms are all full of scams and a lot of illegal activities and so on and so forth. So I think the licensing scheme now is actually quite important to regulate this kind of content. But of course, you need to balance freedom of speech together with this right to control all this other information.
Yeah, agree. Yeah, without a licensing scheme, I think it's difficult to regulate. But then again, with licensing scheme, right, how compliant are those social media platforms? I think I will have a question, because if you talk about, let's say, Facebook, right? I'm just picking one of the social media as example. Let's talk about Facebook. If we asking them to, let's say, as an organization, we ask them to take down certain content, right? They may refuse to do it. Like what you say is true. I mean, you have to go to the court and get an order. But if with the licensing scheme, can we go through a local authorities? Let's say we report to 𝗪𝗪𝗁𝗲, let 𝗪𝗪𝗁𝗲 do the work, or
so there will be a new act that is going to come into place called is Online Safety Act. So the Online Safety Act is a new provision in law where the government, where you can actually lodge the complaint with the government, and the government will compel all these these platform providers to do something. So I have a look at the Online Safety Act that is, if not mistaken, coming soon or hasn't come soon. But I remember going to Parliament and then listening to a briefing by the Minister on this Online Safety Act. So that hopefully will be beneficial in a way, is to reduce all this unlawful content. But of course, if let's say Facebook decides to not comply with any of these obligations, then what can we do lah? Of course, we can say fine and so on and so forth. But nowadays, in old days, we only have Facebook. Everybody's relying on Facebook. But now we have more platforms. So let's say Malaysia take a hard stand, is okay, you don't comply, we'll block Facebook. So like, or like what US does, we will block TikTok. So if countries like South Asia has countries in the South Asia has not done that, that thing yet. But let's say all the ASEAN countries all decide, okay, if this guy don't comply, everybody blocks these platforms. I think if we do it collectively, these platform providers will agree to comply. I would say if you really have to give them the stick.
Yeah. So I think I totally agree with you if the licensing scheme is important. But then my only take is that if we do not have a strong, firm standpoint, right, to impose this on the providers, licensing scheme is just a paper. It's just another, paper tiger. So, and it's also not easy to strike a balance also, because if you decided to ban WhatsApp, right, because Facebook, Meta decided not to comply to certain thing, if you decided to ban WhatsApp, what kind of impact that we are facing also, that's also another question. So it's never an easy task. Never an easy task.
Right.
Yeah. So, okay. So, by the way, I think we have gone through a lot of interesting questions. I personally do have a lot of questions coming from some of your friends and audience, but we're already approaching 1 hour mark already. I mean, time really flies. But at this point, do you have anything to conclude about the cybersecurity or anything else you would like to share with the audience? Let's go and share it.
I see a lot of questions, but we don't have the time to.
We don't have enough time.
No enough time. But what I can summarize is from the questions is a lot of questions as does this act apply to me or not, apply to a certain industry or not? So there are a lot of questions, and what are the roles that are of each party. So whether it applies to you or not as an entity, I think one thing is clear, that if the lead sector approaches you and tell you you are an entity, then you are entity. But if you are still neither here or there, then I think it's go back to talk to the sector lead to say that am I part of it or not? If I'm part of it, then what do I need to do lah? The one thing is that sector lead needs to come out with some form of code of practice, guidance, and so on and so forth, and a lot of documentation. As far as I know, those things are not being issued yet. But once it's issued, then those will be applicable to you. So you have to also actively check whether you fall within it. Will be very helpful also. Let's say you are a subcontractor of a possible sector lead, a possible entity, then you may also want to check with the the entity or the lead also whether they fall within or not, because you also need to ensure that you are in compliance with the CSA.
Yes, very true. I think this is always a very frequent question. Am I part of the NCII, CNII? Am I part of the government entities under the Cybersecurity Act? Oh, so from my side, I think there's also another thing I would like to highlight as well. It's like I think I keep repeating the same message. Regardless whether there's an act in place or not, cybersecurity threats is no longer an IT issue. It is a business survival issue. I think this message needs to ring amongst the management of the companies, because in many occasions when we go to a site that got hacked, for example, we go to financial institutions or manufacturers who got hacked, and we were quite surprised that in many occasions the management of the company never think that cybersecurity incidents can cripple the business. They always think that this is an IT problem. We just get an IT guy to come in and solve the IT problem, and backups corrupted, then we just get another backup hardware to come in place. But the thing is, many business owners today still do not see cybersecurity is a business survival issue. It is a business survival issue anymore. We are not talking about fixing IT problem. We are talking about business problems now. So we have seen cases where cyber attacks can easily impact a business and bring this business back a few months before. I mean, they totally lost a few months of transactions record, and they lost in terms of financial benefits. They lost in terms of resources and time when they go to recovery. And just last week, I think many of us are also quite fresh about this news. There were news coming from the capital market where stockbrokers suspected to be hacked, and hackers was using a stockbroker's account, end user's account, to drive the stock price to a crazy price. And then and Bursa and Security Commissions also both have jointly issued a statement about this incident. So it shows that really hacking attacks really can happen in any kind of industries. And sometimes the hackers may use it for their own benefits, or they even have other agendas to use you as a launchpad to attack others. So one thing I foresee is that we will not have any lesser cybersecurity incident. In fact, if you ask me, the trend of cyber attacks, the trend of cyber incidents, there's only going to one direction only, which is up, right? There's no way the cyber incidents is going to reduce anytime soon, right? Especially now when everyone is so much going to digitalizations, and we haven't even touched about the AI yet. I think hopefully one day we establish another webinar to talk about cyber attacks with AI, how hackers are using, how cyber criminals are using AI to carry out cyber attacks using AI. So with that, today I'm very glad to have Qing Leong together. It's not easy to get Qing Leong's time. I think Qing Leong is a very busy lawyer. So I really want to thank Qing Leong personally for your time. And if anyone else in this session, if you enjoy the topics that we talk about, you enjoy the conversations we have just now, please feel free to follow us. We do have webinars on time to time to share about the latest trend about cybersecurity, about the landscape of the industry. And we also invite distinguished speakers like Qing Leong and others to share about their experience in the topic that we talk about. So please capture this screenshot or capture the link. And follow us. We do have Telegram channel, WhatsApp, and also on our Facebook, LinkedIn. We publish cybersecurity related news. So with that, that's all from me. And Qing Leong, anything else from your side?
That's all. I was trying to answer some questions as fast as I can. Sorry if I couldn't answer all the questions. Happy to take any questions offline. Just send me an email. Yeah, that's all about it. Thank you everybody.
Please share your email in the chat group. I think we have questions coming in from the chat group. So please share your email. And also LGMS team, please share our the follow link in the email as well. Yes, your email is very easy to recognize. 𝗕𝘂𝘀𝗶𝘁𝘆.com. Okay. So okay, that's all from my side, and over to you, Rachel.
Thank you, Mr. Fong and Qing Leong, for the informative session. So we will end our session here. Again, if anyone is interested to learn more about the Cybersecurity Act or any other cybersecurity related questions, you may follow us on our social media or email us with your inquiries. So we hope to see you again on our next webinar.
Thanks, everyone.
Thank you.